Hello, everybody. I'm attorney Vincent W. Davis, and today we are going to talk about one of the most stressful and confusing situations a parent can ever experience. We are going to talk about how to handle a divorce case when California Dependency Court becomes involved, and more importantly, what you can actually do step by step to protect yourself, protect your children, and protect your future. Now, if you are watching this video, there is a good chance that you are scared, overwhelmed, confused, angry, or maybe all of those things at the same time. Maybe you are going through a divorce or a custody battle, and suddenly allegations have been made. Maybe someone contacted Child Protective Services. Maybe the Department of Children and Family Services showed up at your home. Maybe there are accusations of neglect, abuse, domestic violence, substance abuse, emotional abuse, parental alienation, or unsafe living conditions. And now you feel like your family law case has exploded into something much larger. One day, you are arguing about custody schedules, visitation, and child support in family court. And the next day, you are dealing with social workers, investigators, emergency hearings, detention reports, supervised visitation, and dependency court judges. What makes this situation even harder is that many parents do not understand that dependency court operates very differently from family court. The rules are different. The procedures are different. The standards are different. The timelines are different. And the stakes are incredibly high. In dependency court, the government can seek to remove your children from your custody. So in this video, I am going to walk you through the practical how-to aspects of dealing with these situations under California law. We are going to discuss what dependency court is, how it overlaps with divorce and custody disputes, how allegations are investigated, how evidence is used against parents, how to challenge bad evidence, how to prepare for hearings, how to document your case, how to work with witnesses, how to preserve issues for appeal, and what legal remedies exist if you lose at the trial court level. This is going to be a practical strategy discussion. I want you to understand the process. I want you to understand the law. And I want you to understand the mistakes parents make that can seriously damage their cases because knowledge matters, preparation matters, documentation matters. And the truth is this: many parents lose not because they are bad parents, but because they walk into dependency court without understanding how the system works. So let's begin. The first thing you need to understand is that family court and dependency court are not the same thing. Family court usually deals with disputes between parents. Dependency court involves the government stepping into the situation because the government claims the child is at risk. That is a major difference. In family court, the dispute is usually between mother and father. One parent may claim the other parent is dangerous or unfit, but generally speaking, family court assumes parents have constitutional rights to custody and visitation unless evidence proves otherwise. Dependency court is different. Dependency court operates under California Welfare and Institutions Code Section 300 and related statutes. The court's primary concern is child safety, and once dependency jurisdiction attaches, the court has tremendous authority over your family. That means the court can order monitored visitation. The court can remove children from your home. The court can order counseling. The court can order drug testing. The court can restrict contact. The court can terminate reunification services. And in extreme cases, the court can terminate parental rights. Now, I want you to understand something very important. A divorce case can become connected to dependency court in many different ways. Maybe during the divorce, one parent accuses the other of physical abuse. Maybe a child says something at school. Maybe law enforcement responds to a domestic violence call. Maybe there is a substance abuse allegation. Maybe there are mental health concerns. Maybe there are claims of emotional abuse. Maybe one parent weaponizes CPS allegations during a custody dispute. And yes, that happens. The reality is that some people use allegations strategically during divorce litigation. Now, let me be clear. Some allegations are absolutely true, and children need protection. But some allegations are exaggerated, some are manipulated, some are false. And dependency court judges know that custody battles can create incentives for false accusations. However, even false allegations can become dangerous if parents fail to respond correctly. That is why strategy matters. That is why documentation matters. That is why preparation matters. Now, one of the biggest mistakes parents make is assuming that because they know the allegations are false, the court will automatically see the truth. That is not how litigation works. Courts decide cases based on evidence. And if the other side has organized evidence, written reports, witnesses, timelines, photographs, text messages, social worker testimony, therapist records, police reports, and school records, while you walk into court emotional and unprepared, you are already in trouble. That is the reality. So let's talk practically. What do you do when dependency court first enters your life? Step one is this: do not panic. Now, I know that sounds easier said than done, but panic causes parents to make terrible decisions. Panic causes parents to overshare. Panic causes parents to lie. Panic causes parents to destroy evidence. Panic causes parents to scream at social workers. Panic causes parents to violate court orders. And panic causes parents to damage their own credibility. The second step is understanding that everything you say can become evidence. Everything, every text message, every social media post, every voicemail, every angry confrontation, every interview, every statement to a social worker, every statement to law enforcement, every statement to a therapist, every statement to the child's school, everything can become part of the case. Now, this does not mean you should refuse to cooperate, but it does mean you need to think carefully before speaking. One of the most dangerous mistakes parents make is talking too much during investigations. Parents sometimes believe that if they explain enough, the social worker will realize they are innocent. Unfortunately, what often happens is that parents provide inconsistent statements, emotional statements, speculative statements, or statements that later get taken out of context. You need to stay calm. You need to stay factual. And you need legal advice as early as possible. The third step is preserving evidence immediately. This is critical. Start gathering documents. Start gathering text messages. Start gathering emails. Start gathering photographs. Start gathering medical records. Start gathering school records. Start gathering therapy records if appropriate. Start creating timelines. Start identifying witnesses, because dependency court cases move fast, very fast. And parents who wait too long to organize evidence often lose important opportunities. Here's an example. Suppose a parent is accused of being intoxicated around the children during an exchange. Now, maybe the accusation is false. Maybe the accusing parent made the allegation during a heated custody dispute. But if you immediately obtain surveillance footage from a nearby store, receipts showing you were somewhere else, GPS data, witness statements, and contemporaneous text messages showing normal behavior, that evidence can become powerful. But what happens if you wait 2 months? The surveillance footage may be deleted. Witness memories may fade. Digital records may disappear. That is why immediate action matters. The fourth step is understanding the importance of credibility. Judges evaluate credibility constantly. Social workers evaluate credibility constantly. Attorneys evaluate credibility constantly. And credibility is not only about whether someone is telling the truth. Credibility also involves consistency, demeanor, documentation, behavior, and reliability. Parents damage their credibility when they constantly change their stories. Parents damage credibility when they exaggerate. Parents damage credibility when they attack everyone involved in the case. Parents damage credibility when they violate court orders. Parents damage credibility when they post reckless things online. And yes, social media can absolutely destroy dependency cases. I have seen parents accused of substance abuse posting videos of themselves drinking during active dependency proceedings. I have seen parents claiming financial hardship posting luxury vacations online. I have seen parents violating no contact orders and then denying it while electronic evidence proves otherwise. Do not underestimate how damaging this can be. Now let's move into the substantive law. Substantive law refers to the legal standards the court applies to determine whether dependency jurisdiction exists. In California, dependency jurisdiction commonly arises under Welfare and Institutions Code Section 300. There are multiple subdivisions. For example, Section 300 Subdivision B often involves allegations that a child suffered or is at substantial risk of suffering serious physical harm due to a parent's failure or inability to supervise or protect the child. Section 300 Subdivision A can involve serious physical harm inflicted non-accidentally. Section 300 Subdivision C can involve serious emotional damage. Section 300 Subdivision D can involve sexual abuse. Section 300 Subdivision J can involve abuse of siblings. Now, here is what many parents misunderstand. Dependency court is often focused not only on past conduct, but future risk. That distinction matters. A parent may argue nothing happened, but the court may focus on whether there is a substantial risk something could happen. That means even without actual injury, the court can still intervene. For example, repeated domestic violence in the home can create dependency jurisdiction, even if the child was not physically injured. Why? Because California courts recognize that exposure to domestic violence can place children at substantial risk of harm. Substance abuse allegations operate similarly. The court may examine whether alleged substance abuse creates an inability to supervise or safely parent the child. Mental health allegations can operate similarly. The issue is often whether the condition impairs parenting ability or creates safety concerns. Now let's talk about family law overlap. In divorce and custody disputes, California Family Code Section 3011 and related statutes govern best interest analysis and custody determinations. But once dependency jurisdiction exists, dependency court generally takes priority. That means the dependency judge may control visitation, custody, placement, and reunification issues. Family court orders may become secondary. This creates enormous frustration for parents who believe their family law case should control. But dependency jurisdiction changes the legal landscape. Now, another important legal principle involves the burden of proof. At the jurisdictional phase, the agency generally must prove allegations by a preponderance of the evidence. At disposition, removal findings may require clear and convincing evidence. These standards matter because they affect litigation strategy. Understanding the burden helps you understand how aggressively evidence should be challenged. Now, I want to emphasize something very important. A dependency petition is not proof. An allegation is not proof. A social worker report is not automatically true. You have rights. You have the right to contest allegations. You have the right to cross-examine witnesses. You have the right to present evidence. You have the right to challenge hearsay in certain contexts. You have the right to counsel. And in many situations, you have appellate rights, but rights only matter if properly exercised. Now let's walk through the actual dependency court process. Typically, the process begins with a report to Child Protective Services. That report may come from a teacher, doctor, therapist, police officer, neighbor, relative, or one parent during a custody dispute. The agency investigates. That investigation may involve interviews, home visits, medical evaluations, school contacts, and safety assessments. If the agency believes immediate intervention is necessary, it may remove the child or seek protective orders. Then a dependency petition may be filed. Once the petition is filed, The first major hearing is often the detention hearing. This hearing occurs quickly, very quickly, and this is where parents often make mistakes because they walk into court completely unprepared. At the detention hearing, the court decides whether the child should remain detained or whether the child can safely remain with a parent subject to conditions. The agency will usually present reports. The parents may respond, attorneys may argue. The court may issue temporary orders regarding placement and visitation. Now, one strategic issue here involves whether the parent presents evidence immediately or reserves certain evidence for later contested hearings. That decision depends on the facts, it depends on the allegations, it depends on the strength of the evidence, and it depends on litigation strategy. After detention comes the jurisdiction hearing. This hearing determines whether the allegations in the petition are true. This is critical because sustained findings can affect custody rights, employment opportunities, reputation, future family court proceedings, immigration consequences, licensing issues, and even future dependency proceedings. At jurisdiction, the agency must prove the allegations. Witnesses may testify, documents may be introduced, cross examination becomes extremely important. Then comes disposition. Disposition focuses on what orders the court should make. Should the child remain removed? Should reunification services be ordered? Should visitation be monitored? Should counseling be ordered? Should drug testing be ordered? Should domestic violence programs be ordered? The court develops a case plan. Now, here is a major issue many parents fail to appreciate: compliance matters. I understand that some parents feel angry about participating in programs they believe are unfair or unnecessary, but refusing services can seriously damage your position. Courts often interpret refusal as lack of insight. That is extremely important. Dependency court places heavy emphasis on insight. Does the parent understand the alleged problem? Does the parent acknowledge risk factors? Does the parent demonstrate willingness to address concerns? And over time, the court decides whether reunification should continue. Now, that does not mean you must falsely confess to things you did not do, but litigation strategy requires careful thinking. There are ways to comply strategically while still contesting allegations. This is why experienced counsel matters. After disposition, the case continues through review hearings. There may be 6-month reviews, 12-month reviews, and permanency planning hearings. The court examines progress. The court examines compliance. The court examines visitation. The court examines the child's well-being. Now, if reunification fails, the case can move toward termination of parental rights. That is why early strategic action is so important. The beginning of the case often shapes everything that follows. Now, let's talk about evidence. This is one of the most misunderstood areas of dependency litigation. Parents often assume that if something is unfair, inaccurate, or hearsay, the judge will automatically disregard it. That is not always true. Dependency proceedings have unique evidentiary rules. Social worker reports are frequently admitted. Hearsay exceptions may apply. Children's statements may sometimes be admitted under statutory provisions. Medical records may come into evidence. School records may come into evidence. Police reports may influence the case even if no criminal conviction exists. So what can parents do? First, understand the importance of objections. Objections preserve issues. Objections clarify disputes. Objections can limit evidence, and objections may become critically important for appeals. Now, I want to explain something practical. A good objection is not just yelling objection. A good objection identifies a legal basis. For example, hearsay, lack of foundation, speculation, relevance, improper opinion, authentication problems, leading questions, assumes facts not in evidence, argumentative questioning. Now, dependency court judges often allow significant flexibility in evidence, but that does not mean objections are meaningless. Preserving objections can matter tremendously later. Let me give you an example. Suppose a social worker report states that the child said father hit mother repeatedly. Now, maybe the statement is inaccurate. Maybe the child was coached. Maybe the statement was mistranslated. Maybe context is missing. You may challenge reliability. You may challenge interpretation. You may challenge foundation. You may cross examine the social worker regarding interview methods. You may seek inconsistencies. You may present contradictory witnesses. You may present electronic evidence. You may introduce photographs or records. And sometimes expert testimony becomes important, particularly in cases involving mental health, substance abuse, child interview techniques, or allegations of coaching. Now, let's talk about credibility attacks. Cross examination is often one of the most powerful tools in litigation. Good cross examination exposes inconsistencies, it exposes missing information, it exposes bias, it exposes exaggeration, and sometimes it exposes outright fabrication. For example, suppose one parent claims the other parent was constantly intoxicated during custody exchanges, but text messages from those same dates show friendly and normal communication. Suppose photographs contradict timelines. Suppose school attendance records undermine claims. Suppose medical records contradict injury allegations. These details matter. Now, another major evidentiary issue involves documentation. Contemporaneous documentation can be incredibly persuasive. Judges often place significant weight on records created near the time of events. Why? Because memories fade, stories change, litigation influences narratives, but contemporaneous records can appear more reliable. This includes journals, text messages, emails, calendar entries, receipts, medical appointments, therapy attendance, school communications, photographs, GPS data, phone logs, visitation records, drug testing results, counseling completion certificates. And I want to say something important here. Parents should never fabricate evidence. Never. Fabricated evidence can destroy your credibility permanently. Once a court believes you manipulated evidence, your entire case becomes compromised. Honesty matters, accuracy matters, consistency matters. Now let's discuss organization, because organization can dramatically affect outcomes. One of the best things a parent can do is create a master timeline, a detailed timeline, chronological, organized, accurate. This timeline should include major events, dates, court hearings, police contacts, hospital visits, school incidents, visitation exchanges, text messages, drug tests, counseling sessions, therapy appointments, protective order filings, and any important interactions with the agency. Why is this important? Because dependency cases generate enormous amounts of information. Reports become hundreds of pages long. Multiple hearings occur. Different attorneys become involved. Different social workers rotate onto the case, and parents who remain organized are better positioned to challenge inaccuracies. Here is what often happens. A social worker report contains an incorrect date. Another report repeats the incorrect date. Then a later report assumes the incorrect information is true. Suddenly, an inaccurate narrative becomes embedded in the case. But organized parents can identify inconsistencies. They can point to records. They can point to communications. They can point to contradictions. Now let's talk about witnesses. Witnesses can be critically important. Teachers, doctors, neighbors, relatives, counselors, coaches, friends, supervisors, childcare providers, therapists. These individuals may provide context that the court would otherwise never hear. But witness preparation matters. Witnesses should understand the importance of truthfulness. Witnesses should stay focused on facts. Witnesses should avoid exaggeration. And witnesses should avoid speculating about things they did not personally observe. One of the fastest ways to weaken testimony is through speculation. For example, a witness who says, "I personally observed mother interacting appropriately with the child on multiple occasions," is giving factual testimony. But a witness who says, I know father invented all these allegations because he is evil, may appear biased and speculative. That distinction matters. Now, another practical point. Do not assume the judge automatically knows your history. Many parents walk into court believing the judge will somehow intuitively understand years of context. That is not how litigation works. You need evidence, you need organization, you need strategic presentation, you need coherent narratives supported by facts. Now, let's discuss one of the most common issues connecting divorce court and dependency court: domestic violence allegations. Domestic violence allegations can dramatically alter custody and dependency proceedings. California law treats exposure to domestic violence very seriously. And importantly, dependency courts often focus not only on direct physical harm to children, but the emotional and environmental impact of violence within the household. Now, here is where things become complicated. Not every argument is domestic violence. Not every accusation is true. Not every police response proves abuse. And not every restraining order request is justified. But once allegations enter the system, they can shape the entire case. The court may issue emergency protective orders. The court may order monitored visitation. The court may require batterer intervention programs. The court may examine text messages, photographs, body camera footage, witness testimony, prior reports, and medical evidence. Now, let me talk strategically. Parents often make devastating mistakes in domestic violence cases because they react emotionally. For example, violating no contact orders, sending angry messages, showing up unexpectedly, posting online attacks, attempting to influence witnesses, or confronting the reporting party. All of this can severely damage your case. Another major issue involves mutual accusations. In many relationships, both parties accuse each other. Dependency court must then determine credibility, risk, and safety concerns. And this is where documentation becomes incredibly important. Photographs, medical records, witness testimony, police reports, prior communications, electronic records, 911 recordings. All of these may become relevant. Now, I also want to address false or exaggerated allegations. They do happen. And when they happen, they can be incredibly destructive. But the response must be strategic. You do not combat false allegations by losing emotional control. You combat them through evidence, consistency, documentation, witnesses, cross-examination, and careful litigation strategy. Another major area in dependency litigation involves substance abuse allegations. Now, substance abuse allegations can arise in many different ways. Maybe there was an arrest. Maybe there was a DUI. Maybe someone reported drug use. Maybe prescription medication issues exist. Maybe there were allegations during custody exchanges. Maybe a child reported concerning behavior. Now, under California law, the issue is often whether substance abuse creates a risk to the child. That means the court examines parenting ability, supervision, judgment, safety, stability, and insight. One important practical point is this: if the court orders testing, compliance matters. Missed tests are often treated like positive tests. Parents sometimes believe avoiding testing helps them. Usually it hurts them. Another important issue involves prescription medication. Some parents assume that because medication is legally prescribed, dependency court will not care. That is incorrect. The court may still examine impairment, misuse, interactions, dosage issues, and parenting impact. Now let's discuss strategy. Suppose a parent struggles with alcohol. One strategic approach may involve voluntary treatment, counseling, AA participation, therapy, consistent testing, and documented sobriety efforts. Courts often respond positively to proactive accountability, but denial without evidence can become dangerous. Now, this does not mean parents should falsely admit addiction. But strategic legal positioning matters. Remember, dependency court focuses heavily on risk management. Judges want reassurance that children are safe. That means proactive conduct can matter tremendously. Now, let's talk about mental health issues. Mental health concerns can become central in dependency litigation, but it is very important to understand this. Having a mental health diagnosis does not automatically make someone an unfit parent. That is extremely important. The legal issue is generally whether the condition creates a substantial risk to the child or impairs parenting ability. Now, unfortunately, mental health allegations can become highly emotional. Parents may feel stigmatized, parents may feel attacked, parents may feel humiliated, and some parents stop treatment because they fear treatment records will be used against them. That can become a mistake. Courts often view treatment compliance favorably, therapy participation, medication compliance, psychiatric follow up, counseling, stability. All of these can demonstrate responsibility. Now, another important issue involves psychological evaluations. Sometimes the court orders evaluations. Sometimes parties retain experts. Sometimes the agency relies on mental health professionals. These evaluations can carry enormous weight, which means preparation matters. Consistency matters, and understanding the evaluator's role matters. Parents should also understand that statements made during evaluations may become evidence. So, honesty and thoughtfulness are critical. Now, let's talk about visitation. Visitation becomes one of the most emotional parts of dependency litigation. Parents often feel devastated when visitation becomes monitored. Children feel confused, families feel disrupted, and emotions run high. But here is what I want parents to understand: visitation is not just emotional, visitation is evidentiary. Every visit can affect the case. Supervisors may write reports, social workers may observe interactions, children may make statements, behavior patterns may be documented. Now, let me give practical advice. Show up on time, be calm, be appropriate, avoid discussing litigation with the child, avoid coaching, avoid interrogating the child, avoid negative comments about the other parent, avoid emotional outbursts, and focus on the relationship. Now, here is another major issue. Some parents become so angry at the system that they stop visiting. That is usually disastrous. Consistent visitation demonstrates commitment. It demonstrates parental bond. It demonstrates effort. And visitation records often become important evidence later. Now, let's discuss procedural law and the California rules of court. Dependency proceedings operate under extensive procedural frameworks. The California Rules of Court establish timelines, notice requirements, hearing procedures, and filing requirements. These rules matter. Deadlines matter. Procedural compliance matters. One missed deadline can have serious consequences. For example, notice requirements regarding hearings can affect due process issues. Rules regarding writ petitions can affect appellate rights. Rules regarding evidentiary objections can affect preservation of issues. Parents sometimes believe that because dependency court feels informal at times, procedure does not matter. That is incorrect. Procedure matters tremendously. Now let's discuss continuances. Parents frequently ask for delays because they feel unprepared, but dependency court emphasizes permanency and child stability. That means continuances may be difficult to obtain. This is another reason preparation must begin immediately. Now, another critical issue involves reunification timelines. California dependency law imposes statutory timelines. The court examines progress within specified periods. If insufficient progress occurs, reunification services may terminate. Parents who wait too long to engage in services may find themselves running out of time, and time passes quickly in dependency court, very quickly. Now, let's discuss the attorney-client relationship. One of the most important decisions you make is how you communicate with counsel. Good representation requires teamwork. Parents should provide organized information. Accurate timelines relevant documents, witness names, important communications. Parents should also be honest with their attorneys. One of the worst situations in litigation is when an attorney learns harmful facts in the middle of trial because the client withheld information. Your attorney cannot strategically prepare for issues that remain hidden. Now, I understand something. Parents sometimes fear judgment. Parents sometimes feel embarrassed. Parents sometimes worry about how facts look. But your attorney needs the truth to prepare effectively. Now, another important issue is communication. Dependency litigation moves quickly. Parents should read reports carefully. Parents should attend meetings. Parents should respond to requests. Parents should stay informed. And parents should understand the difference between emotional frustration and legal strategy. Sometimes the best legal move is not emotionally satisfying. Sometimes restraint matters. Sometimes silence matters. Sometimes patience matters. Sometimes strategic compliance matters. That is why experienced guidance is important. Now let's talk about appellate remedies. Because many parents ask this question: what happens if I lose? Well, first understand this: not every bad ruling automatically gets reversed. Appeals are complicated, and appellate courts generally defer to factual findings if substantial evidence supports them. That is why creating a strong trial court record is essential. Appeals often focus on legal error, procedural error, abuse of discretion, insufficient evidence, due process violations, improper admission or exclusion of evidence, failure to provide reasonable services, or incorrect application of law. Now, timing matters tremendously in dependency appeals. Some orders require writ petitions. Some deadlines are extremely short. Missing deadlines can destroy appellate rights. That is why immediate consultation after adverse rulings is important. Now, let me explain something else. Appeals are generally based on the record. That means appellate courts examine transcripts, exhibits, filings, and objections made in the trial court. This is why objections matter. This is why organization matters. This is why preserving issues matters. You cannot usually raise entirely new evidence on appeal. Now, sometimes parents may also pursue extraordinary writs. Sometimes there may be requests to modify orders. Sometimes there may be changed circumstances. Sometimes reunification efforts improve. Dependency litigation can evolve over time. But strategic legal action is essential. Now I want to spend some time discussing common mistakes, because understanding mistakes can help parents avoid them. One major mistake is failing to take allegations seriously. Some parents assume the truth will automatically prevail. Unfortunately, dependency litigation does not work that way. Another major mistake is emotional communication, threatening texts, aggressive voicemails, social media rants, online attacks. These things can become devastating evidence. Another mistake is noncompliance, missing drug tests, skipping counseling, ignoring visitation, violating court orders, failing to appear. All of these can damage credibility. Another major mistake is failing to stay organized. Parents lose documents, forget timelines, fail to preserve evidence, miss deadlines, or fail to communicate effectively with counsel. Another mistake is focusing entirely on attacking the other parent while neglecting self-improvement. Dependency court often focuses heavily on parental insight and protective capacity. Judges want to know what you are doing to stabilize the situation. Now, another important mistake involves discussing the case with the children. Do not coach children. Do not pressure children. Do not interrogate children. Do not place children in the middle of litigation. Courts take this very seriously. And finally, another mistake is hopelessness. Some parents give up. Some parents stop participating. Some parents become overwhelmed. But persistence matters. Consistency matters. And strategic effort matters. Now let me give you a practical hypothetical. Suppose there is an ongoing divorce. The parents are fighting over custody. One evening, police respond to a domestic disturbance. No arrests occur, but the child tells a school counselor the next day that mommy and daddy were screaming. The school makes a CPS report. The agency investigates. During the investigation, the father alleges the mother abuses prescription medication. The mother alleges the father has anger issues. The child is interviewed. The agency files a dependency petition. Now, what happens next? The detention hearing occurs. The court orders temporary monitored visitation for father. The mother is ordered to participate in counseling. Drug testing is ordered. The family court custody case effectively pauses, while dependency court takes priority. Now imagine two different responses. In the first scenario, the parents become combative. They violate orders. They post online attacks. They miss services. They refuse testing. They argue with social workers. They fail to document anything. The case deteriorates. The court becomes increasingly concerned. Now imagine the second scenario. The parents immediately retain counsel. They preserve evidence. They organize timelines. They comply strategically. They participate in counseling. They maintain appropriate visitation. They avoid inflammatory communications. They document progress. They challenge inaccurate allegations through evidence. Those two paths can lead to dramatically different outcomes. That is why strategy matters. Now, let's talk more specifically about investigations. Parents often feel intimidated when investigators arrive. And I understand why. These investigations feel invasive, they feel frightening. But again, strategy matters. You should understand your rights. You should understand that cooperation does not require self destruction. You should remain calm. You should avoid speculation. You should avoid volunteering unnecessary information. You should avoid emotional escalation. Now, another practical issue involves home conditions. Keep your home organized, safe, appropriate. Dependency investigations often examine environmental conditions, food, sleeping arrangements, cleanliness, medication storage, firearms, hazards, supervision issues. All of this matters. Another important issue involves third parties. Who lives in the home? Who visits the home? Do they have criminal histories, substance abuse issues, violence histories? Dependency courts examine household environments carefully. Now let's discuss digital evidence. Digital evidence has become central in modern dependency litigation. Text messages, emails, social media posts, location data, videos, photographs, messaging apps, all of these can become evidence. Now, parents sometimes underestimate how permanent digital communications are. Deleting messages does not always eliminate them. Screenshots exist, backups exist, metadata exists, cloud storage exists. Now, here's practical advice. Assume every communication could eventually appear before a judge. That mindset alone can prevent many disastrous mistakes. Avoid inflammatory language, avoid threats, avoid insults, avoid reckless posts, and avoid discussing litigation publicly online. Another important issue involves authenticity. Digital evidence may require authentication. Who sent the message? Was it altered? Was context removed? Was the account hacked? These issues sometimes become important evidentiary disputes. Now let's discuss reunification, because ultimately many parents want to know this. How do I get my children back? The answer depends on many factors. But generally speaking, reunification involves demonstrating safety, stability, insight, compliance, and parental capacity. The court wants evidence that problems have been addressed. That may involve counseling, substance abuse treatment, domestic violence programs, parenting classes, mental health treatment, stable housing, employment stability, consistent visitation, and demonstrated behavioral change. Now, here is something important. Courts often focus more on demonstrated change than promises. Promises matter less than conduct. A parent may say, I will do better, but the court wants evidence, attendance records, completion certificates, negative tests, positive visitation reports, therapist feedback, stable behavior over time. Consistency matters, and yes, Time matters. Courts often want to see sustained stability, not just temporary improvement immediately before hearings. Now, I want to speak directly to parents emotionally for a moment. Dependency litigation is exhausting. It affects sleep, it affects finances, it affects relationships, it affects mental health. And many parents feel isolated and ashamed, but you need to stay focused. You need to stay disciplined. You need to think long term. Do not let temporary emotions sabotage permanent outcomes. Every hearing matters. Every report matters. Every interaction matters. And your children are watching how you respond. Now, I also want to say this, not every case ends in disaster. Many parents successfully reunify. Many parents overcome allegations. Many parents improve their situations. But successful outcomes usually involve preparation, accountability, organization, and strategic legal action. As we begin wrapping up, I want to leave you with several practical principles. First, take every allegation seriously. Second, preserve evidence immediately. Third, stay organized. Fourth, comply strategically. Fifth, avoid emotional communication. Sixth, document everything. Seventh, understand the procedural timelines. Eighth, prepare for hearings carefully. Ninth, focus on credibility. And 10th, get experienced legal guidance as early as possible. Dependency court cases connected to divorce and custody disputes are some of the most complicated cases in California law. You are dealing with overlapping systems: family court, dependency court, protective orders, social workers, investigators, therapists, school personnel, and often intense emotional conflict. But strategy matters, preparation matters, evidence matters, and understanding the process matters. If you or someone you know is dealing with dependency court issues connected to divorce, custody disputes, allegations of abuse, social worker investigations, or reunification concerns, it is extremely important to get experienced legal guidance. These cases move quickly. The consequences are serious, and mistakes made early in the process can affect the entire case. So if you need help, call us at 888-888-6582. Visit our website, www.vincentwdavis.com. Subscribe to our YouTube channel, Davis Divorce Lawyers. And you can also schedule a consultation online at www.vincentwdavis.setmore.com. Remember this: you are not powerless. You do have rights, and preparation can make a tremendous difference. I'm attorney Vincent W. Davis, and we are all in this together.